I am talking today on civil procedure and what kinds of lessons you might want to give a mentee if you are a mentor addressing issues that young lawyers and new lawyers might need to face when they are dealing with civil procedure issues. The advice that I have always given to every young lawyer that I've worked with and that was given to me as a young lawyer was, with respect to civil procedure rules, read the rules, read the rules, read the rules. People come in and ask me questions all the time about really basic things that are in the rules of civil procedure. They're there before you want to ask a question of a judge in particular, but somebody else. I strongly encourage you to pick up the book and read it. The more you read it, the more you will understand it. The more the colleagues that you work with will appreciate your understanding of what is going on in a case. A rule that I think is actually really important and that I see mistakes on all the time are lawyers who sign pleadings in the name of their law firm. Rule 11 specifically requires an attorney to sign the papers. So when you sign, you should sign with your name, and underneath it should be your name. It shouldn't be law firm by you. And I think this is very important because if you are a lawyer and you're signing something and you think you're signing on behalf of another entity, you're less likely to take seriously the obligation of Rule 11 to put only what you believe to be good faith arguments in a brief or in a paper, and to put only facts that you believe could be substantiated or that have a good faith basis. And when you draft a complaint, it should be short and plain. Include key facts so that the person reading it, the judge, the opposing party, has an idea of what you're arguing, but you don't need to throw in a laundry list of every possible fact that relates to the circumstances of the case. A complaint should be just what the rules say, a short, plain statement of the case. And as Judge Bruce Jenkins once said, you only need one good claim to win. So when you draft a complaint, think of the 2 or 3 causes of action that are really relevant to your case. Don't draft a complaint with 50 different causes of action that will only confuse people, irritate judges, irritate opponents, and waste everybody's time and money, including your own clients. And clients really don't appreciate it when you waste their money. When you're answering a complaint, when you're answering the complaint, you have to think about compulsory counterclaims. If you don't assert a compulsory counterclaim, as I'm sure you will remember from law school, you can lose it. So this is one of the places where you need to stop and think very carefully about everything that's happened in the case that resulted in the filing of a lawsuit, and talk with your client about what claims that they have that are related to that lawsuit that they need to file back in return, or that they're willing also to waive. Sometimes clients don't want to assert the compulsory counterclaim, but if that's true, make sure you get an email or a letter from them saying they're aware of the compulsory counterclaim and they don't want to file it. At the outset of a case, if you're a defendant, think about removal. If you don't timely remove a case from state court to federal court, you can lose the ability to remove it. And that can be a serious issue that you need to think about. There are big differences between state and federal court. Sometimes it can be a judge-related issue, but oftentimes it's just as simple as in federal court, if you're a defendant, you have to have a jury say that you were wrong, and it has to be unanimous, and it has to be 12 people on the jury. If you're in state court, the rule is just 6 out of 8. So if you're a defendant, it's typically better to be in federal court, and it's very important to advise your clients of their right to remove, assuming that diversity exists or there's federal question jurisdiction. Rule 16 conferences. Rule 16 conferences are great. Rule 16, under both the federal rules and the state rules, gives the judge the ability to impose order where there is chaos. Cases can often get very complicated, very fast, and get out of hand. And when you find that you're involved in a case where somebody's filed 10 different motions within 1 week, what you want to do is get in front of the judge and say, hey, we have 10 motions. Some of them are important, some of them are not. Let's resolve the ones that are important first and deal with the ones that are less important later, or that might be mooted by resolution of the early ones. So always think about how you can help the court and the parties keep things organized. That will make life much easier for you as you litigate a case. Always be courteous in litigation. Being courteous and polite to opposing counsel will make your life easier over the long haul. It will keep your blood pressure low and probably prolong your life. There's no purpose to being discourteous to other lawyers, and if you're ever asked for an extension, you should always give it. Now, if somebody asks you for 6 months, you can say, no, that's not reasonable, but give them a reasonable amount of time to respond. There's almost no excuse to not giving an extension. The only possible excuse that I could ever think of is if you filed a motion for a temporary restraining order, and the motion will become moot if you don't get it heard on the timeline that you need it heard on. And even then, think about whether or not you filed a motion for a TRO that's actually seeking to stop a harm that's irreparable. A lot of times people file motions for TRO and they're totally strategic. There's really nothing that's going to change the world if you don't push that out for a couple of days or a week if you need to. Before you file any sort of motion, whether it's a motion for an extension or a motion trying, for a Rule 16 conference, for instance, call opposing counsel. You would be surprised what people will agree to if you actually pick up the phone and talk with them. Not everything needs to be sorted out by motion practice and litigation. A lot of things, if you're dealing with experienced lawyers or even inexperienced lawyers who are open-minded, you can resolve many of your issues simply by picking up the phone. And this is a advice that was given to me as a young lawyer that has proven invaluable. I don't know how many hundreds of thousands of dollars have probably been saved by just picking up the phone and talking to opposing counsel about a problem and how we might be able to resolve it. All right, discovery rules. We're moving through the entire rules of civil procedure, which I did bring with me in case anybody in the room were to ask me a question. That's another important thing. Whenever you go to court, bring the rules of civil procedure and the rules of evidence with you. There's no way to resolve a dispute over what the rules say or what the evidence rules say than by opening them up and reading them in court with the judge and the opposing party. Not having the rules of civil procedure with you, especially when you are a young lawyer, can be a fatal error. Okay, knowing the difference between state rules of discovery and federal rules of discovery. A few years ago, the Utah Supreme Court changed the rules of discovery in Utah so that they are very different now than the federal rules, which they used to mirror. Under the new discovery rules in the state of Utah, for instance, there are very important initial disclosures that need to be made essentially at the outset of the case. So whereas in federal court, you need to identify witnesses and identify documents, in state court, you need to not only identify the witnesses, but you need to write up a summary of what you expect them to testify to at trial. Now that's quite a task if you think about it, to in the first month or so of a case have to identify who your witnesses are going to be and summarize what they're going to testify at trial. And I will tell you from experience that most lawyers right now are actually essentially ignoring this and doing what they used to do under the federal rules and just identifying topics. I strongly urge you to take the time to do as good an outline as you can of the key subjects that you expect your witnesses to testify to at trial. It will keep you out of trouble. It will keep your case focused. There's nothing stopping you from changing that outline later. You can always amend your disclosures, but it's not helpful the way the rules are set up now, and given the timing of disclosures and the timing of discovery, if you don't provide an outline of what your case is really about. And frankly, it's good practice because your clients get an early taste of what the litigation is going to be about. So rather than having clients only figure out what it would be like to be trying the case later and what issues are going to come up, because they learn about it at their deposition a year and a half after the case has been filed. Now they're forced to think about what they're going to have to do to win this case or to defend the case virtually at the outset of the litigation. There are differences not only in disclosures but in expert discovery as well that are important to understand. And in federal court, you get an expert report that gets disclosed to you, and then you can take the deposition of the witness. After that, in state court, after you disclose who your witness is going to be, you make an election, or after the other side discloses who their witness is going to be, you make an election, and the election is whether you want a written report or the opportunity to take a 4-hour deposition. Now, my personal preference is to always take the deposition because people don't explain as much in written reports as they will if you take 4 hours to talk to them about what their opinions are and what the basis of their opinions are. And I think you will find a lot more, even though it costs a little bit more to take a deposition under the new rules. Now, those rules work fine in a small case where there's not a lot at stake, and 4 hours is enough to go through what you need to go through with an expert. However, if you find yourself in the position that it's a very complicated case, the expert testimony is going to be very in-depth, and there's lots of money at stake, you can always ask the court for additional time. Don't be ashamed to ask the court in the right case for both an expert report and the opportunity to take a deposition of 7 hours or more if it makes sense. Given all of the new deadlines that are in place in discovery and the fact that they run from the filing and the response to a complaint, make sure you have a good docketing system. The easiest way to commit malpractice as a young lawyer is to miss a deadline because it wasn't calculated properly, and you look at your calendar one day and you're thinking, wow, it's February. This case has been going on for an awfully long time. Do I need to take depositions? And then you figure out that, in fact, you can't take depositions because the discovery cutoff's passed. So if you're not at a big firm where you have a docketing system that's imposed on you by the firm administration, make sure you have a system in place to protect yourself from making those kinds of mistakes and finding yourself in the position of having to ask a judge that you need additional time because you, frankly, simply forgot what the discovery cutoff was going to be. Discovery, this is a simple rule that I like. Drafting subpoenas is really easy. Drafting any form of a discovery request is really easy. Focus on what it is that you need. Don't ask a million interrogatories. Well, you're not even allowed to ask for a million interrogatories. There's limits on that. Don't ask for a million. Don't put down a million document requests. If you're writing a subpoena, don't include 20 pages of instructions and admonitions to opposing counsel that don't mean anything. The rules of civil procedure govern how people respond to a subpoena, for instance. So the fact that you have included an instruction saying, please give me, for instance, an explanation of every document that you've determined to be missing from your production. Well, if you want a witness to tell you what documents are not in their production because they may have been destroyed 5 years ago, a subpoena for documents is not the proper way to do that. What you need to do is take a deposition or, as I mentioned before, pick up the phone and politely ask opposing counsel if they can identify any documents that may be missing, and they may cooperate or not. But don't ask people to do what's beyond the requirements of the rules of civil procedure. If you are in a case where there is electronic discovery, this is a new area. I'm sure you learned a lot about this in law school. Everybody loves the technology of electronic discovery. My most important advice to you is to negotiate an e-discovery protocol at the outset of discovery so that you know what you're going to be getting into. Fights over electronic discovery are incredibly costly. So if you know, for instance, how you're going to agree on search terms or what the search terms are going to be, do that up front. If you know that there's technology, as I'm sure you are aware, that will eliminate a lot of unnecessary documents, but not everybody agrees on which technologies to use or why. Negotiate that beforehand. Negotiate things like which document custodians are going to have their computers forensically imaged, so you don't find yourself in a position having to take forensic images of 100 witnesses when there are really only 4 witnesses whose computers matter. This is one of the easiest ways to waste your client's money, not taking control of electronic discovery early on and not making sure that the scope of electronic discovery is rationally related to what's actually at issue in the case. If it's a $50,000 case, don't spend $200,000 doing electronic discovery. In terms of brief writing, keep your briefs short and to the point. Judges don't have time to read the entire saga of the case that you have dealt with your client. When they're resolving a motion, they need to know the facts that are relevant to that motion and the applicable law. Also, the page limitations and the rules on motions are important. 10 pages is about the right amount of pages to explain almost anything to a judge. I have found, as I have gone through practice, that there's almost nothing that I can't explain, no matter how complicated an associate might tell me they think it is. There's nothing that can't be explained in 10 pages or less. And judges appreciate extremely a brief that is concise and to the point. Don't ask for more time unless it's the rare, or more time rather. Don't ask for more space unless it's the rare case where the facts are so complicated and the law is so complicated and there's so much at stake that it makes sense to do that. And even then, don't ask. Figure out a way to keep your legal argument to 10 pages or less. On summary judgment motions, only material facts. The easiest way to lose a summary judgment motion is to include a lot of facts and claim they're undisputed that have nothing to do with the legal issue that you're trying to resolve. Judges just want to know which facts are material and undisputed, and which facts are material and undisputed, and then legally relevant to the argument that you're trying to make. And again, keep it short, keep it simple, make the judge's life easy. If you hand the judge a motion for summary judgment that's 100 pages long and looks like this, the joke is there has to be a question of fact in there somewhere, and they'll just deny it out of hand and out of frustration. Finally, and I'm skipping over all of the civil procedure rules related to trial because I think those are for the second installment of this video. When you lose your case and you think you should have won, don't forget to file a notice of appeal. The notice of appeal deadline is 30 days after the final order or judgment. You'd be surprised how many people let that slip. The Court of Appeals loses jurisdiction over a case if a notice of appeal is not timely filed, and clients become extremely upset if that occurs. So with that, I thank you for your time. I wish you luck as new lawyers and as mentors and mentees.